It's my pleasure to be joined by Kate Hartley, an attorney with the Pacific Justice Institute, to talk about some cases that are going on right now, as well as some larger legislative issues. Kate, thanks for joining me.
Thanks for having me, Brian. I appreciate it.
Well, first of all, before we get into the details, can you tell us about yourself and what you do?
Absolutely. Yeah. So, as you said, I'm an attorney based in Coeur d'Alene. So, I'm up in North Idaho, and I work for a group called Pacific Justice Institute, and we primarily litigate in the areas of religious liberty and parental rights. And so we have cases all over the country, but my focus is right here in Idaho, where I reside. And we have many, many cases pending all over the country, including here in Idaho.
So, one of those cases, you brought to my attention recently, involves regulation and homeschooling, and maybe a little, just maybe a hint of, latent bigotry. I don't know. I guess that's, in the eye of the beholder. Tell us about that case.
Yeah, so we represent a woman. Her name is Heather Jones, and she's from up here in North Idaho. And she graduated from a homeschool program provided by her parents. And she actually graduated years ago, about 10 years ago, from a homeschool program provided by her parents. And her family complied with Idaho state law in giving this program. They provided her transcripts. They provided her diploma when she completed the program. And specifically for this family, their decision to homeschool was deeply religious. And so they were prompted by their faith to homeschool in the first place, and obviously also incorporated faith-based teachings into their curriculum and into her program. And so 10 years go by. Miss Jones is a successful entrepreneur, and she wants to become a real estate agent and obtain a state real estate license from the state of Idaho. And so she goes through the education required to do that, takes the testing, and goes to apply, and is ultimately denied a license because she graduated from a homeschool program. And so she appealed that decision and was still not granted a license. And so got a hold of us, and ultimately we very recently filed a federal case stating that this decision by the state licensing agency violates her free exercise of religion rights, as the decision to homeschool was deeply rooted in religion and in her faith. And this is a huge burden placed on religious families who require homeschooling as part of their faith, to ultimately not be allowed to obtain a state benefit in state licensure because of that decision.
Now, what in Idaho law makes it so that they have the ability to deny somebody for homeschooling? Homeschooling's been legal here for a long time. It's, very protected and appreciated. How are they getting away with that?
It's a very good question, Brian. As you said, Idaho has fantastic homeschooling laws, and everything that this family in particular did, was in compliance with that. Idaho code, says that, one can educate their children at home, and all the way through, and that is recognized in our state code as a valid graduation of schooling. And so what the problem is that the licensing agency is saying that, well, but you still didn't meet the requirements that we have for licensure, which say that you have to, graduate from a quote accredited school and in order to obtain a license. And what the disconnect seems to be is that Miss Jones did that according to state law. And so they're having trouble connecting, our homeschooling laws with the licensure laws that state that an applicant must have graduated from an accredited school. In Idaho, a homeschool program is equivalent to graduating from an accredited school. So That's the problem, our client is facing. I have no doubt there are others in the state who have faced similar issues, and this is a really important issue. There's a lot of homeschool families, as you know, in our state who either have or could be affected by a policy such as this.
I'm just trying to imagine. I graduated quite a long time ago, and I went to a public school, but I'm imagining if I'm applying for a license or a job somewhere, and they say that I can't have it because I didn't take some one specific class in my high school tenure. It seems irrelevant to me whether or not she got a homeschool diploma or a public school diploma or a private school diploma. Can she do the
Right.
job? Does she meet the
Right.
requirements?
Exactly. And specific to this woman, she's already had she's been successful already. She's proven to be successful in running businesses and being an entrepreneur after her graduation from her homeschool program up till the present. And as you said, it's irrelevant at this point what may or may not have been included even in her homeschool program to begin with. And it's a shame that it's being looked at in that way. These agencies are designed to protect the consumer and protect the public, and we don't see any logical connection to denying her license as a means to protect the public.
Yes, apparently you have to worry about if your real estate agent who is selling your house or buying your house was homeschooled.
Exactly. Yes. Even if you've gone through the real estate education, passed the exam, that, should be telling, right, that you are equipped to do that job, and that should be the end of the story. But unfortunately, for Miss Jones, it's not the end of the story.
So you said you filed this in federal court. Can you explain why you went to federal court as opposed to a state court?
I will. So specific to her case, and I realize this is not true of everyone who could be affected by a situation like this. This decision for Ms. Jones and her family at the time was a religious one, and so we are claiming that, this is a substantial burden on a religious family like this one deciding to homeschool. And so that leads us to the First Amendment, which protects, the free exercise of religion and the ability for families to make decisions such as this. And so that's why we have filed in federal court. So it's a First Amendment claim under the federal Constitution.
Is there a way that Ms. Jones could, rectify it, maybe by getting a GED?
That's a great question. The code does allow for a GED as an alternative. The problem with that, again, in her situation, is that to take the GED, you have to affirm that you never graduated from high school. And she did. And she did lawfully according to the laws of Idaho. And so she can't, in good faith, state that she didn't graduate and go ahead and take the GED as an alternative.
Interesting. So if she tried to go that route, she'd basically be lying.
Exactly. Right. And she refuses to do that.
So what's the timeline on this case? How soon is it going to be heard, and what are the steps in that?
Always the magical question with litigation. This case is very early on, and so probably nowhere near a resolution, unfortunately. And so very beginning stages. I do think this could also be addressed, at least to some extent, legislatively. And so hopefully this is brought to the attention of legislators who can help Ms. Jones and others like her from a legislative standpoint. And I certainly hope that happens. But as far as litigation, it's very, very early on. So it's tough to say.
Yeah, you mentioned legislation with the session starting in about 3 or 4 weeks now. That seems to be a reasonable course. Just go into the occupational licensing rules and clarify that homeschooling counts as school. Do you have any specific ideas for legislation that could fix that? And have you talked to any legislators about it?
I have spoken to a few legislators. I ultimately am not privy to anything specific that may be planned to address this. I am very hopeful that it will be addressed in some way. But yes, we need to rectify and officially recognize within the licensing statutes that a homeschool graduate that has a homeschool diploma and a homeschool transcript is considered equivalent to graduating from an accredited school, and it should be as simple as that. But legislation is never simple, as you know.
No, and Department of Occupational and Professional Licensing, it's one of those agencies I haven't scratched too deeply into, but it's huge and it's very complex.
Yes.
Now, this case and this discussion is taking place in the context of kind of a larger discussion about, church and state, religious institutions. There was a case. I don't know if your organization was part of it, where a religious organization was using a school, I think it was, and they were kicked out because they didn't want to allow a religious organization to do it. I should have looked that up before we started here. But yeah, this discussion and debate is going on all over the place, and with the new parental choice tax credit, that's added yet one more part to it, because people can take the tax credit for reimbursement of expenses for religious private schools or religious instruction, as long as it meets all the other requirements. But then there's this big thing in our Constitution, the Blaine Amendment, that people always point to, saying that, no, you can't do that. You and Matt Edwards recently submitted an op-ed that I was happy to publish, talking about the outdated Blaine Amendment. Tell us what it's all about and what should be done.
Yeah, Brian, and thank you for highlighting this problem that we have in our state constitution. And the case you're referring to, I believe, is Truth Family Bible Church, who we did represent in federal court, who, yes, they were a church meeting in a public school facility and had their lease with the school terminated because the school was about to receive bond funding to expand their facilities. And the bond issuers stated that because of the Blaine Amendment, which we will talk about, they could not continue to lease space to the church in order to receive bond funding. And so thankfully that case is resolved, and the judge that heard the case was in agreement that that was violative of the church's First Amendment rights. And so what is this Blaine Amendment and why is it being used? It's part of many different state constitutions, Idaho included, of course, and it essentially forbids public funding from going to a church or a religious entity. And the history of it goes back to the late 1800s and is rooted in preventing monies from going specifically to Catholics. And even more specifically to fund Catholic schools for the most part. And so it's very clearly rooted in anti-Catholic bigotry, and unfortunately has been utilized, since that time against many different faiths, primarily against people of the Christian faith, but truly from all faiths since that time. And it's very problematic, and it resulted in quite a bit of litigation over the years out of numerous different states, including ours, when government entities utilize this Blaine Amendment to discriminate against churches, against religious groups, religious individuals, from state benefits that they would otherwise be qualified for. And they're saying, because of this Blaine Amendment, we are going to disqualify you from receiving that benefit. And so it's a problem everywhere in the country, including our state. And it's time to repeal this part of our state constitution. From my view, especially because if it's repealed, then no one is trying to lean on it to discriminate. If nothing else, it removes the confusion of, well, this is part of the law that we're supposed to follow. Again, these agencies or individuals, municipalities, whoever it is, are tasked with following state and federal law. And if that is part of state law or our state constitution, it creates confusion. And fundamentally, these Blaine amendments are in conflict with the First Amendment religion clauses, the free exercise clause and the establishment clause. And it's time to get our legislature on board with repealing this.
I've got a few questions about that came up as I was listening. First, isn't it already unconstitutional? Wasn't there a Supreme Court case a few years ago that said that if public money is going to some organizations, then they can't discriminate against religious organizations from receiving the same funds if they otherwise qualify?
Correct. There's actually numerous Supreme Court cases that have said that, and unfortunately, it continues to happen. I think the government entities try to get around that, saying, well, this is a slightly different context than what the Supreme Court addressed. And so therefore, we can go ahead and continue to use the Blaine Amendment. And so unfortunately, that's what we've seen. The Supreme Court time and time again has been taking these cases and admonishing the government entity for using the Blaine Amendment to discriminate.
Second question, I've already seen people using the Blaine Amendment as an excuse to go after the parental choice tax credit. I think that's even part of the lawsuit that was filed. However, I haven't seen anybody complain about the launch grant, which is it's actually, they use the term vouchers for the tax credit because they know people don't like the word voucher. But if anything's a voucher, it's the launch grant, because it's money that students can then apply to a school or a trade school or on-the-job training. And I'm told that they can take it to places like BYU Idaho or Northwest Nazarene, or places that are religious in character. Why do you think nobody's complained about that?
This is why I say it brings up confusion, if nothing else. How is this supposed to be applied? When does it apply? How do we balance the fact that we have this Blaine Amendment in the Constitution, but we also have all of this federal court precedent under the First Amendment saying, no, you cannot discriminate against people who want to use those state offered funds at a religious institution. And I think that again, if I'm giving people the benefit of the doubt, especially, it's confusing and they don't know how to apply it when they are making these decisions. And I think that was the situation for Truth Family Bible Church. I think there was just a lot of confusion about what laws apply in what contexts, and that causes some of these problems. Certainly there can be people who have overt animus towards religious people, in which case it's not necessarily confusing. They're intentionally using it to discriminate. But many times I don't think that's the case. I think there's it brings up a lot of confusion. And the U.S. Supreme Court has been very clear on this. But I think it's time for the individual states to also be that clear and say, we are going to completely remove this from our Constitution so that it is very clear that we apply First Amendment principles in these contexts, and we can completely ignore this Blaine Amendment and any precedent that's come out of the Blaine Amendment.
I recall there was a resolution in the legislature last year to put a repeal of the Blaine Amendment on the ballot, because as a constitutional amendment, it would have to go before the people and get after getting 2/3 of the legislature. I think one of the things people were concerned about is that you had, self-described Satanists go in to committee and testify about how great this would be, because then they could get federal money. And I think they were just being a bit of, kind of trolling. But I think it did raise some concerns with some of the folks. If we repealed it, would we have to fund, Satanist schools or, Muslim madrasas or, anything else that is, more contrary to the values of the majority of Idahoans?
Yes, that's a really good question. It does come up. And the short answer is yes, all different religions would be able to have access to whatever state benefit is at least potentially offered by the state. States aren't required to offer benefits in that way. But if they do, they can't discriminate against religious people or religious entities. And it's a great question. My personal view on that is that's more of a cultural issue. I think that There, a lot of those fears are probably unfounded. That would you know, lead to a lot of state funding going towards the Satanic Temple, for example, because that's been specifically brought up. But no, you can't discriminate against them if they are otherwise qualified to receive funding from whatever state benefit we're talking about. And so I think that is more of a cultural issue, and ways in which we should promote goodness and faith in the community and in our state. That will all come to play.
Well, it'll be interesting to see if it comes up again this year. It's been contentious. It'd be interesting to go back over the last 150 years and see how many other debates there have been over this before we get to this point. I know the history of jurisprudence on anything relating to religion or promotion of religion is long and varied and complex.
Very much so, and I expect the same with this. And it's, as you alluded to, it's a big task to remove part of the state constitution. We need 2/3 of the legislature, and then it would have to go on the ballot, and the citizens would have to vote on it. And so it would require a lot, from both the legislature and I think, properly educating people in the public as to, okay, what does this truly mean if we remove this, and highlighting people who have been harmed, like Truth Family Bible Church, like others in our state and in our country that are just regular people, and they're going about their business, and something like the Blaine Amendment has been used to discriminate and harm them. And so it's a big ask, for sure. But I think why not now? Why not start the conversation and start putting some pressure on the legislature to really take a look at this, look at the history of it. Has a very discriminatory history. It's still being utilized in a discriminatory manner. And do we really want that to happen in our state? And that's what we have to take a really good look at.
It's interesting to me how, James Blaine has been dead for well over a century, but his ghost still haunts us today.
Absolutely. It certainly does.
And it goes to show that the things that we do today could have an impact a century from now. And so we've got to be really thoughtful about those things.
That's a great point. You're absolutely right.
So is there anything else that you're working on that you'd mind sharing now?
Sure. Kind of in the same Blaine Amendment theme, we represent people, also homeschool families, who have been denied state funding because they have independently chosen religiously based curriculums. And so we have a couple cases going like that. One's pending in the Ninth Circuit. And it's the same concept. So the school said, because of the Blaine Amendment, yes, we offer this program where parents can independently choose the curriculum they use to teach their own children in their own homes. And because you're supported by a public school, there's this benefit we're offering that will reimburse for the curriculum. And you can choose anything you want, unless you choose a religious curriculum or a curriculum that has religious overtones. And again, using that Blaine Amendment as the reasoning behind that. So once again, Blaine Amendment's harming every day people in Idaho who are just trying to homeschool their kids. But they are people of faith, and that's important when they're homeschooling, educating their kids. And yeah, we've got lots of cases, Brian, in the Title VII realm, which is employment discrimination. We've had a lot of cases that are, I would say, starting to wrap up from the COVID era of people being fired for refusing some of the COVID mandates, vaccine mandates. So we've got a lot of those cases going on, and lots of religious liberty cases.
That seems to be one of the big issues of the day. I was thinking from a very, very high, million foot level. Uh, sure, Christianity, Islam, Judaism, Hinduism, those are, what we think of when we think of religions. But if you substitute the word worldview for religion, you have a situation where the government is saying, your worldview that says, there's a God and he has opinions on how mankind should act, that's religion and you can't have that. But our worldview that says, whatever you're learning in public schools, a lot of crazy stuff, well, that's just normal, and that's what your children must get. It's I don't know, maybe we're thinking about it the wrong way.
Exactly. I mean, and what is, how can you be totally neutral? How you have to pick. I think that, can anyone be truly neutral? I mean, and that's what is great about our country and our state, is that we get to make those individual decisions, for ourselves, for our families, for our kids, and it's interesting how that happens, and substitute worldview in there, and you get a different answer.
Well, Kate Hartley, Pacific Justice Institute, thank you for your time. Good luck with the case, and have a Merry Christmas.
Thanks, Brian. I appreciate you having me. Merry Christmas to you.